Good afternoon and welcome all of you to the another interesting session on the series Founders 101 Legal and Tax series. This one was, the session is primarily aimed at giving you a quick idea and giving you the long and short of how due diligence work, in investment deals. A lot of you have been, when you get an investor on board and when they sign up a term sheet with you, one of the first things that they generally engage with you on is conducting a diligence on the startup to ensure that it is a commercially viable proposition for them to go ahead with the investment. So in this session we're going to dive a little deep and help you understand what are the different sections or areas of law that the investor usually aims at covering in a diligence. What are the issues that come up in a typical diligence process, and how do you remedy them? So essentially, how do you get your house in order before your investor starts telling you how things are to be rectified? To start with and give you a background of what is a legal due diligence or what is a due diligence in the common parlance. So due diligence, as some of you would be aware, is a comprehensive appraisal of your business, which is essentially undertaken by an investor or a buyer or a acquirer, especially to establish the assets and liabilities of your startup and evaluate your commercial potential, whether it's a good proposition to go ahead with it or not. So while the numbers are laid down on the table when your term sheets are signed, and in terms of their investment amounts, in terms of the broad rights that the investors will have in your company, a due diligence essentially makes the investor aware of what is the health of the company, whether it is financially the health of the company or from a compliance standpoint or from a legal standpoint, whether the company or whether the startup is healthy enough for the investor to come in. And if not, then you need to remedy those compromised positions before the investor puts in the money. Essentially the concept of due diligence hinges on the Neo-Latin phrase caveat emptor. What does that Neo-Latin phrase mean? It essentially means let the buyer be aware. Yeah, is it better now?
This is better. Yeah, much better.
Okay. Sorry. I'm hoping that the audience were able to gather the first few lines of the session. Otherwise, I'll just do a quick recap.
Just quickly browse.
A quick recap of the opening lines. So essentially, what a due diligence means is that it's a comprehensive appraisal of the business, which is undertaken by a prospective investor or a buyer, especially for the purposes of establishing the assets and liabilities of the startup and to evaluate the commercial potential of the startup. While the numbers, etc., are freezed during the term sheet stage in terms of the investment being brought in by the investor and the broad rights that it will have, after it has invested into the company, the legal diligence helps him to understand the financial and the compliance and, the legal health of the company, whether it is in good shape, and if it is not, then what are the steps that need to be taken for it to get in good shape before they can invest their monies into the company. The concept of due diligence basically hinges upon, the principle that the buyer should be responsible for checking the quality and suitability of the products or services before a purchase is being made. Though it was, it originated in the, in the context of goods and services, the principle of caveat emptor, as we call it, it stands true even in the context of the VC investment deals, where the investors liked to check whether the startup is ready in terms of compliances and finances, for the external investor to come in. What are the different types of diligence which are undertaken by an investor? There are two essential, broad kinds of diligence which are undertaken. One is, in terms of the broad buckets, one is a legal diligence where they cover all the, legal areas and compliance areas. And the other is in terms of the financial diligence, where they check and review the financial statements of the company, the annual returns of the company, the balance sheets, the P&Ls, etc., so that the numbers are making complete sense to them, before they invest. In terms of the legal diligence, there are again two, broad subsets, I would say. One is a red flag diligence report, where the investor essentially wants to cover only broad areas of law, the key areas or the key topics that it is really interested in. It's primarily the share capital history, the employees and the the HR policies, and the loans and the financial indebtedness of the company. Then there is a detailed diligence which is also undertaken by investors, and this is the more usually sorted method which is adopted, which is a detailed diligence in which all areas of the company are thoroughly looked at, and a detailed diligence report is prepared by the lawyers engaged for conducting the diligence, where every aspect of the company is checked. Dates back to a look back period of about 3 to 4 years, and a detailed report is thereafter issued. Diligence, how is it typically conducted? The process of getting a startup diligence up and running is, let me tell you, a very labor intensive and a greatly time consuming process, specifically for the founders, because you have to, the investors can ask in for papers and documents which can date several years back. You may not have all of them in order, so you may have to work on producing all those documents and the right documents to the investors. And it may be time consuming. You may have to, shift your focus from business for a slightly, if I may say, for some time till your diligence is over, so that you can concentrate on the requirements of the investor in the diligence process. So be prepared for that. Typically, how the process is run is that the lawyers or the advisors who are running the process from the investor side will send you a requisition checklist, which will essentially be a detailed question, in a Q&A format, where they will lay down all the documents or information that they require from your end. A data room will be set up, while you can have a physical diligence, but I think nowadays people are preferring that an online data room is set up, whereby all your documents and information is uploaded online. So you go ahead and set up that data room for the investor and their advisors. The documents are reviewed, and thereafter an additional requisition list can also be given by the advisors, basis which further information requests can be sought. This is how typically a diligence process is run before it can be concluded and a diligence report can be issued to your investor. The different subjects that are essentially covered in a legal DD are share capital history, labor compliances, contracts, loans, insurance, litigation, and a couple of other finer topics as well, in terms of registrations, licenses, registers, etc. So, how do you really get your startup to get its ducks in a row to land an investment? In this session, we're trying to make an attempt to let you know, all that you need to prepare your startup for a diligence process and get it right from the beginning. So over to you, Anusha. If you may just give us a quick, to start off with share capital history, and how does, the diligence around the corporate sections and the corporate finance looks like, because that being the most important and one of the, critical areas which an investor really wants to look into and see if the company has done and followed the processes right.
Thanks, Harshita. Before we go into addressing what are the key issues we typically see in most early stage startups in corporate section, let me just give you a brief background of what sort of questions we as lawyers ask in the requisition list. So we typically ask the company for their basic corporate and charter documents, such as your articles of association, memorandum of association, and certificate of incorporation in case you're a private company. Details of the directors, past directors and present directors, minutes of all meetings of the company since incorporation if it's a very early stage company, then register of members and all the filings that have been made by the startup, and check a fully diluted share capital table and all the loans and borrowings that have been taken by the startup. Now, a lot of this data is also publicly available on the MCA website. So all of you can go onto the MCA website and enter the company's name, pay your nominal fees, and download public information such as forms and details of directors, etc. But there are some documents which are internal documents, such as your minutes of meetings, statutory registers, etc. And from a legal point of view, we always request the company to provide us the entire data, and we cross-verify it with what has been filed online as well. So now let's get into what are the key issues that we very often see in early stage startup. The first issue that we will speak about is the share issuance. Now, in case of a very early stage startup where there are only 2 promoters and they have only been subscribers to the memorandum and articles with no further capitalization in the company, there would be no issues as such that we would see with issuances, and it would be very clean. However, in many early stage startups, what we see is that there are shares which are issued to key employees or key personnel, and there are some shares which are issued to angel investors. Now, a lot of time, what we see is that when you issue shares to third parties, who are not already shareholders in the company, then Section 62(1)(c) and Section 42 of the Companies Act, which is your sections dealing with private placement, need to be followed. There are very procedural sections, and many a times we notice that most of these startups do not follow the strict procedure of law as provided under the Companies Act. For instance, when you issue shares to a third party, then there's a special resolution which is passed by the shareholders of the company, and such special resolution has to be filed online on the with the ROC in form MGD 14. And similarly, when you issue shares, a return has to be filed in form PAS 3 within 15 days of shares being issued to such persons. Now, we typically notice that companies default when it comes to delay their filings. So when we find these issues during our diligence, what we generally recommend is that the company make these filings on the online platform as soon as possible, along with the late payment fees. The late payment fees is directly calculated on the online platform if you mention the date on which the file should have, on which the actions were taken and the date on which it's being filed. Automatically, there is an inbuilt provision of calculating your penalty. So we request that companies complete all these procedural lapses prior to investments coming in. Then moving on to the next key issue that we typically see, and this probably is one of the most important issues in relation to share certificates. Now, a certificate is a title to evidence if you're shareholding in the company. It is a very important instrument, and it must be correctly and validly issued to any person. Now, under the Companies Act, a share certificate needs to be signed by 2 directors or a director and a company secretary. These are procedural requirements, and sometimes companies do make a mistake in this, but we inform them on how the same can be corrected. However, one major issue that we see in most companies, early stage companies, is that a share certificate needs to be adequately stamped in accordance with the state stamp laws. And in most cases, these share certificates are not stamped or are inadequately stamped. When I say inadequately stamped, companies sometimes pay the stamp duty only on the face value of the share and not the premium that was paid on the share. So for instance, if I issue one share of face value 10 and inclusive of premium to be 100, instead of paying stamp duty on 100 rupees, companies end up paying stamp duty only on 10 rupees. And that is inadequate stamping under law. Now, under law, as I mentioned, this is a state-specific subject on how stamping works. So for instance, if your company is incorporated in Karnataka, the stamp duty for your share certificate would be 0.1%. However, if it's incorporated in West Bengal, the stamp duty would be just 1 rupee on your share certificate, irrespective of the consideration. So therefore, it's very much necessary that you need to look at your state-specific laws of where your company is incorporated and ensure that stamp duty is adequately paid. If it's not adequately paid, like we've seen in most cases, we will have to recommend that the company go for the adjudication process with the sub-registrar, pay the penalty that will be imposed for inadequate or non-stamping default. Typically, the penalty under law is up to 10 times the stamp duty payable, but generally, if you correct this discrepancy early on, the registrar does not impose a very high fine. We have helped some companies in the past correct these deficiencies, and it has taken a while, for instance, 1 or 2 months for these discrepancies to be corrected. So it's best to ensure that you do not make this mistake while you're issuing shares, that your share certificate is stamped on or prior to issuance from day 1 itself. While again, just adding on here, an investor who is subscribing to new share certificates, new share capital in the company may not be so fussed about non-stamping of share certificates helping shareholders. However, tomorrow if there's a 100% exit from the company, or in case the investor wants to purchase some secondary shares from these promoters, it will pose to be a big issue. So therefore, we ensure that this issue, irrespective of whether it directly impacts the investor, is corrected as soon as it's identified in the Series A stage itself. The next issue that we find in most early stage startups is with respect to share transfers. So typically under Companies Act, a share transfer is valid when there is a share transfer form executed by the transferor and transferee, and the share transfer form is adequately stamped. Thereafter, the share transfer form has to be taken on record by the board. Now, these are internal documents, and what we have noticed in early stage companies is that in case there is any share transfer that has taken place, companies inadvertently forget to stamp the share transfer form adequately at the time of transfer. So for instance, currently, actually, before I give you an example, the stamp duty currently payable on share transfers in India is 0.25% of the consideration payable. However, there is an amendment that has been brought out in the Finance Act, and hopefully, I think it should come into effect on July, although the date has been pushed multiple times. And the stamp duty would be reduced from 0.25% to 0.015% only in case of a physical transfer. So let me tell you what sort of an issue we typically see in these share transfer forms. For instance, if you're transferring just one share from person A to person B for just INR 10 rupees, most companies, because 0.25% of 10 rupees, they consider it to be very nominal and completely forget about it. But because of such a issue, the will be void. And tomorrow, if the person B wants to sell the share sell that share to the investor, we would flag this as a red flag issue, stating that the transfer, although the stamp duty payable was minimal, less than 1 rupee, is questionable. And until such a discrepancy is corrected, that is, you go to the sub-registrar's office and pay the penalty for non-stamping, we would recommend that this transfer be kept on hold. So as you would see, that something as simple as not stamping for 1 rupee could significantly delay your transaction if there's any secondary sale where your investor would like to purchase some shares from the promoters or key employees. So please ensure that all your share transfer forms are properly and adequately stamped at the time of the transfer itself. Moving to the next issue that we see is with respect to the share capital table. Now, in a very early stage startup where there are only promoters in the company and no other, quite clean, and we don't really see any issue, is that in very early stage startups, many contractual promises are made to key employees over email or via a contract stating that they would be entitled to a certain percentage shareholding in the company. Now, the problem with such promises is that there is no details on what is the price at which this employee would be granted this shareholding, at what date would this employee be granted shareholding. All this information is not available. Now, given that such promises could affect the shareholding of the investors in the sense that it could dilute their stake or question what is the amount of shareholding that the investor has gotten, we flag this as a red flag issue to the investor, and we request the company to form a proper employee stock option plan in accordance with the Companies Act. In fact, we've done a previous session for the startup series talking about the different types of ESOP plans that can be incorporated by the company. So please do refer to that to understand what sort can be incorporated. And thereafter, we ask the company to execute a release letter with these employees saying that they have no claims against the company for any shares, and the fact that the ESOPs have been granted will suffice. So this is another aspect that you must keep in mind when you promise any stake to any key employees or new early stage employees in your company. One other issue that in the corporate section, the final issue that we would like to discuss, and what we've seen not only in early stage companies but in late stage companies, is that there is no proper maintenance. 4 board meetings in a year and at least 1 AGM in a year. The minutes of these meetings are not captured properly. While if there's any filing required, companies usually create a certified true copy of the resolution that they would want to file and file it online, whereas the actual copy of the same resolution is not maintained in the minutes book. And when an audit happens, this is generally picked up and issues can come up because we do not even see that this resolution has been passed actually in the books of the company. So while it might seem procedural and painful for an early stage startup, we highly recommend that you maintain your minutes books and maintain all your statutory registers, everything up to date. Any good company secretary can help you with maintaining all these actions so that there are no issues that come up and delay your funding when you finally reach that step of funding. Moving to the corporate finance section, as Harshita had pointed out, typically a finance due diligence is also conducted on an early stage company, and they generally go in detail into the financial health of the company. However, from a legal perspective, we do go over some aspects of the audited financials of the company to understand if they are in compliance with corporate laws. One very issue that we see in many companies is in relation to loans. So we noticed that a lot of companies take loans from their unrelated, like from their friends or friends of friends, and thereafter, instead of repaying the loan, they convert this into equity. Now, under Companies Act, if you've taken a loan from anyone who's not a shareholder or director or a relative of such shareholder or director, then such a loan is considered as a deposit, and you will have to follow deposit regulations. And it's a very there are high penalties when you take such loans which constitute deposits. So please ensure, and once that loan has been converted to equity, it is very difficult for us to undo what has already been done, and the company will have to live with this historic mistake that it has made. So please ensure that anytime you take loan or from your friends of friends who are not relatives of your shareholder or the director, or not the shareholder or director himself, please ensure that that loan is repaid, or you will have to follow the due process under the Companies Act on how this loan can continue in the books. And last issue that we typically point out from the financials to the investor is related party transactions. So typically, from the financials, we notice what are the related party transactions that have been undertaken by the company and the promoters. And if they're not an arm's length on an ordinary course of business, we flag this off as an FYI to the investors, letting them know that these are certain related party transactions that have taken place, and for your information. And commercially, the investor can take a decision on they make of such related parties transactions. So to sum up, as Harshita had mentioned, corporate is one of the most important sections of diligence and most important, most procedural sections that need to be taken care of by the company. Please ensure that anything with respect to which concerns title to shareholding, either of the promoters, key employees, or of the investors, is absolutely correct with no mistakes, because this will be one section where no investor will agree to rectify post the investment. They will want it to be rectified prior to the investment, and this will significantly delay your investment round. Back to you, Harshita.
Thank you, Anusha, giving them an overview of of the corporate compliances framework. From here on, I have my next question to you, Aishwarya, in terms of what are the typical issues that we encounter when we review registration certificates, compliance with labor and employment laws, promoter agreements. What are the typical issues that we find in those areas, in a startup?
Sure, Harshita, thank you. So, when we undertake an employment diligence, a labor and employment diligence, we typically ask the companies for the various registrations that they have obtained under various labor laws, whether they are contributing to the Provident Fund, employee state insurance for the eligible employees, whether they are complying with the Maternity Benefit Act, the Prevention of Sexual Harassment Act, the Bonus Act, and various other labor laws. And whether you have codified employment agreements with your employees, at least the key employees, promoter agreements, and also whether you have policies that you have entered into or provided to the employees regarding their roles and responsibilities. So in India, in case of employment issues, they stem from various legislations. We all know that there is not just one legislation in relation to labor laws in India, but multiple legislations across states. Across various states, and also the central laws. So basis, various legislations, and we have, identified important issues that we come across basis the legislation. So now, beginning with the Shops and Commercial Establishments Act. So each state has their own specific Shops and Establishments Act, and every commercial establishment or shop must get themselves registered under this act. So, even if you are a shop down the lane, or if you are a services sector company, or you're an ITS company, you need to get yourself registered under this act. So, and there's a time period within which you need to get yourself registered, and sometimes these registrations also have a validity period for the registration, say 1 year, 5 years, or 10 years. So it's important that you track the validity period and get themselves renewed on an annual basis, or 5-year basis, or 10-year basis. And in some cases, you will also need to mention the business that you are engaged in the Shops and Establishment certificate while applying for the Shops and Establishment certificate. So you need to ensure that you give a proper description of your business so that there is no ambiguity with the labor officers later. For example, now we have seen companies where they may be engaged in the ITS services sector, but the shops and establishments registration certificate does not mention that specifically. So then there arises ambiguity as to whether the benefits available to the ITS sector companies are available to this company, because the shops and establishments registration certificate is not very clear. Then you have the Maternity Benefit Act. So while most companies know that once you have 10 or more employees, you need to have you need to ensure that you provide maternity leave, and this is not just 10 or more women employees, but 10 or more employees including men. You need to provide leave according to the maternity benefit policy. And the other important requirement that has recently come up is providing a creche facility in case you have office locations with more than 50 employees. So even if you have, say, an office in Mumbai and Bangalore, you need to, with 50 or more employees, you will need to ensure that you provide creche facility in both these office locations. Then there's the Employee Provident Fund Act. And as we all know, it's an important social security legislation in India. And once you may start off with 5 or 6 employees, but once you reach the 20 employee threshold, your establishment will get hit by the Provident Fund Act, and you will need to apply for registration under the Act and contribute Provident Fund for all employees who are eligible to receive contribution. So there's a basic salary limit for eligible employees. We also see situations where employees are not making Provident Fund contribution for employees who were employed with the previous employer and was eligible to receive Provident Fund contribution with the previous employer. But in case of this employer, the threshold has not met. So one has to take into account these factors also and ensure that the Provident Fund contribution is being made under the law. And the other requirement is the employee state insurance. Again, there is a threshold limit once you hit a certain employee limit. And if you have employees drawing a certain number of wages, ensuring that you get yourself registered under this act and provide the insurance cover to the employees. The other issue that we come across is in compliance with the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act. So most companies are aware now that you need to have a policy in place, irrespective of the number of men or women employees. And if you have more than 10 employees in a particular branch or location, you need to have an internal complaints committee for that office. So again, you may have, say, 20 employees in Bangalore and 10 employees in Mumbai. You have to ensure that you have a committee in both these locations. We typically see that companies have only one internal complaints committee across all locations. And there are also requirements as to who can constitute part of the internal complaints committee. Then employers have to also conduct training, sensitize their employees on this anti-sexual harassment. Then we see issues from the perspective of the Contract Labor Regulation Act. So who are contractors? Basically, persons engaged through agencies or contractors, like you have your housekeeping staff, security guards are known as contract laborers. So they are actually employees on the rolls of the contractor or the agency, and the person whose office they work at pays wages to the contractor, and the contractor pays them all the dues and even makes contributions on behalf of them. So while they are not an employee on your roll, if you are engaging a certain number of contract laborers, then you will need to get registration under this act. So this again varies from state to state. We see that in some cases, the companies have met this threshold of contract laborers and have not obtained the registration. So it's important that this registration is also kept in mind. In addition, most importantly is the Gratuity Act. So employees who have completed a certain number of years of continuous service are eligible to gratuity at the time of their resignation or cessation of employment. So while at the beginning of at the early stage of the company, this may not matter, but you need to ensure that you accrue for this liability in your books so that you at the end of 5 years, when an employee is leaving, you realize that you have not accrued for any gratuity liability and you're not sure where to pick it from. Sometimes companies may also have a trust or an insurance for gratuity. I mean, the reason why you need to comply with all these laws is one, fines. You will also be subject to a lot of notices by the labor authorities. Some of them have, criminal imprisonment. You will need to pay penalty. You will need to, these are the sort of issues that we come across when if you don't obtain the registration or don't apply for renewal. Then the other requirements under these acts are also ensuring that you publish your shops and establishment certificate in a location in your office, or you maintain certain registers, returns, and make filings under these laws. So we see that these are some of the finer nuances. So which need to be ensured. You need to ensure that you maintain them or comply with them, so that you don't see any inspection by labor authorities or unnecessary notices and unnecessarily lies with the labor authorities to get these rectified, because the fines under most of these statutes are quite low. Then moving on to employee documentation. So we usually see that the terms of employment are not adequately documented. Sometimes it's just an email confirmation of employment or an offer letter which briefly lays down the joining date, designation, and does not contain detailed terms. When we undertake a diligence, we usually look whether these employment agreements have adequate rights and obligations of both the parties are captured, whether they have confidentiality obligation, intellectual property assignment, non-compete, at least during the term of employment, non-solicit, dispute resolution. What is the period of termination? How can an employer terminate the employee, whether on for misconduct? What are the grounds? Then what is the notice period? How long is my notice period? What are the wages that I can give in lieu of the notice period? It's important that all these are properly codified. And if we see that there are no proper employment contracts, then we may ask to execute fresh employment contracts with capturing all these terms. The other issue that we usually see, which Anusha also touched upon in case of share certificates, is that we see that these employment agreements may not be stamped. So the agreements which are not stamped are not admissible in evidence in a court of law. So typically, employers believe that you don't need to submit these employment contracts as of now as evidence in a court of law. This may arise in case of a dispute situation. So then, why stamp it and incur costs? So then, typically we see that at least key employee contracts or with founders are at least stamped, and so that there is no issue in the future. Then the other important thing is codifying policies, leave, anti-sexual harassment policy. So while there is no specific law in relation to codification of policies other than under the Prevention of Sexual Harassment Act, which requires employers to have an anti-sexual harassment policy, we also see that sometimes the leave, etc., to employees is also mentioned to them so that they know what are their leave requirements, policies. And leave is something that is governed under the state-specific Shops and Establishments Act. So if you have locations, offices in various locations, then you need to ensure that you're in compliance with the Shops and Establishments Act of each location for the leave that you're providing. Then the Information Technology Act requires you to maintain a privacy policy, which I will deal with separately when I talk about the intellectual property rights. So that's about it. Over to you, Harshita.
Thank you, Aishwarya. I think so. The key that we draw from Aishwarya's submission on the labor and employment laws was that the key is really the compliance to the laws, because the moment there is a non-compliance that the investor observes, that is exactly where they want you to rectify and pivot and get back to the book of the law in terms of managing your businesses. Over to you, Anusha, in terms of material contracts. So just a quick line here before we get on to material contracts. So a lot of these startups, we, when we conduct due diligence, we observe that they do not really focus on executing a contract, long form or a short form, with their vendors and customers. As a result of which, they either end up, documenting their relationship in a purchase order or in an email format. So let's understand what are the issues that we've seen when we review documents and from an investor perspective, and what is it that the investor is really looking for when it says it wants customer agreements or contracts.
Thanks, Harshita. As Harshita has rightly pointed out, please ensure that you have some form of a material agreement in place, especially with your top 5, top 10 customers in terms of revenue. Typically in a diligence, we do ask for copies of these top 5 customers in terms of revenue, for instance, from where you get 75% of your revenue. And we go through this very, very carefully, because at the end, has made some investment in your company and valued your company basis all the revenue and all the material contracts that you have executed with various parties. So please ensure that you have proper documentation in place. So let me just very quickly go over some of the issues that we see in material contracts. First and foremost, as we've been mentioning in all our sections, stamping is again a major issue here. Most material contracts we see are inadequately stamped or are not stamped at all. We understand that a startup may enter into many contracts and it's not actually possible to stamp all of them. However, the call that's taken in the market and we as lawyers take is at least your top 5 contracts or top 10 from which most of your revenue comes must be adequately stamped. Tomorrow, if there is any dispute, we cannot take this contract to a court of law since it will be inadmissible, and you penalties on the same to ensure that it's adequately stamped. The stamping would vary again from state to state. For instance, in Karnataka, it could be around 600 rupees, whereas in Maharashtra, it's ad valorem. So it would be 0.2% of the consideration in the agreement. So depending on where you are, you will have to pay the adequate stamp duty. Just don't stamp it just for 100 rupees and think that it's adequately stamped. Do ensure that you look at the state-specific laws to ensure that whatever is mentioned therein is the correct stamp duty that you pay. The second issue that we see is with respect to uncapped liabilities. Most of the material contracts we see, the liability of the company when it's providing a service is not capped. This is a red flag, especially for very major contracts that you're executing. What is fair and balanced and what is generally accepted in the market is to have your liability capped to either the consideration amount that you have already received under the agreement, or agree to any other lower amount that is mutually agreeable to both parties. So do ensure that you don't have a silent or when it's silent, it is considered uncapped liability clause, because tomorrow in case of any disputes, we don't want the counterparty coming and asking for something which is much more than what the consideration under the contract is. The third important point is that sometimes in major contracts, we see unilateral termination rights. Please ensure that when you negotiate, you have a fair and balanced termination clause in your contract. So we don't want an instance where one customer from whom you get 50% of your revenue has the right to terminate the contract tomorrow for no reason. That would be a cause of concern for the investors. Typically try to negotiate for a fair clause, which is having 30 days notice in case of a breach, with 15 to 20 days to correct that breach, and thereafter having the right to terminate instead of immediate unilateral termination right. And the last issue that we typically see in material contracts is with respect to change in control. This is not really an issue, but more of a procedural requirement. A lot of your contracts you execute with other parties may have a clause saying that if there's any change in shareholding in the company or any change in the board of directors of the company, you must take our prior permission or you must intimate us. So depending on the nature of the change of control clause, that is whether it's intimation or notification, we typically request a company to ensure that the proper compliance is done prior to closing the investment so that the third party is aware of a change in control. Do ensure that you don't have a clause which says that in case of any change in shareholding, this agreement will unilaterally terminate, because that would again pose to be a big risk for an investor who's coming in. So just to sum up, Ensure that you have a proper contract in place, ensure it's adequately stamped, and ensure that all your conditions are properly, all the contractual terms are properly negotiated. What we recommend when we come across contracts which are one-sided is that the company renegotiate these terms and ensure that fully and adequately stamped and proper balanced terms are executed prior to the investment coming in. Depending on how important these contracts are, sometimes they can be pushed to post-investment coming in. Back to you, Harshita.
Thank you, Anusha. Over to you, Aishwarya, in terms of explaining on how important is documenting and registering your intellectual property, because that remains the key of a lot of these startup businesses. So is it, what is it that is really required to be going right in terms of your intellectual property registrations, documentation, having a good robust clause on intellectual property protection in your employment and consultancy agreements? So what is it that we really require, and what goes missing when we do a diligence?
Sure. Thanks, Harshita. So in terms of intellectual property, one of the most important aspects that we look for when we are diligencing a company is where does the ownership of the IP lie? So typically, employees are the ones creating the IP for you, be it, say, copyright, patents, trademarks, domain names. They are the ones who are creating the IP. So has the IP properly been transferred or assigned from the employee to the employer, such that the company is the owner of the IP? This is very important in case of asset-light companies like tech companies who do not have any assets, and their main value or the asset lies in the IP that they create. So depending on the nature of the IP, the nature of relationship, whether it is employer, employee, or consultant, the ownership of the IP will vary. So in case of an employer-employee relationship, in case of any copyright that is created, so copyright includes literary works, which includes all computer programs as well. Then copyright in any work created by an employee will automatically vest in the employer. This is by virtue of the Copyright Act. But in case of patents and trademarks and other IP, the inventor will be the creator, that is the employee, will be the first owner of the IP and not the employer. Similarly, in case of a consultancy arrangement, which is not an employee relationship, where you engage an independent contractor, then irrespective of whether it is patent, copyright, or trademark, the IP rights will vest with the consultant and not with the employer in the first instance. So it's important that the employment agreement, or even by way of a separate intellectual property assignment agreement, you adequately capture the assignment right under these contracts. So one of the important aspects to ensure that you mention the term of the assignment, whether it is forever or for a certain period of time, because otherwise, if you don't mention the term under law, it will be deemed to be a certain number of years as per each law in relation to trademark or copyright. And if you don't mention the territory of the assignment, then it will be deemed to be India, where in India. So it's necessary to mention that it's a worldwide assignment across all countries and continents that the assignment is being made. It's also important that the employees waive any moral rights that they have over the intellectual property that they have created, or any reversionary rights. That is, if the intellectual property is not used within a certain period of time by the company, then they will reverse to the company. So reverse to the employee. So it's necessary that these rights are also waived, which is provided under law. Then, so that the company has adequate ownership over the IP. The other issue that we see is domain names. So when a company purchases a domain name, usually an employee may have purchased it for the company. And sometimes we also see that employees have left the company, but still the domain name is registered in the name of the such employee. So it's important that the domain name is registered in the name of the company and not an employee or individual. And also from an intellectual property assignment perspective, if an employee has created IP and has left the company, then if the assignment has not been properly made, then we see that the company may be left with no IP, and it may be very difficult to get hold of the employee to sign adequate assignment or transfer documentation. Then we also see that employers may collect personal data of employees. Like personal data can be biometric information, bank account details, medical records, or sometimes not only of employees but also of customers if you're very customer facing, and you may be storing them electronically. So in such cases, under the law, the companies, that's the IT Act as of now, you need to have a privacy policy, and you also need to have ensured that you have taken consent of such an individual, that is the employee or customer, for collecting the information. And the other requirements under the Act is that you need to have a grievance officer, and ensure that you maintain adequate security practices. So we see that employers are usually collect such information, and are not aware that they need to maintain a privacy policy or ensure that they've at least taken specific consent of the employees and have documented that they have taken such a consent. Over to you, Harshita.
Thank you, Aishwarya. From here on, I think we quickly move on to dealing with some other not so critical sections, if I may say that, are the ones which are insurance, litigation, what do we see in real estate, and lease deeds, etc. Which what are the key issues that we see here, Anusha?
Sure, Harshita. So just quickly going over, in insurance, typically in an early stage startup, there are not many insurance requirements. One point that we do point out is a directors and officers insurance policy. This is generally an insurance which is taken to insure any directors for any insure persons for any liabilities that may be imposed on them for them to in their capacity as directors. So therefore, when an investor is taking a seat on a board, this is generally built into the shareholders agreement and also during the due diligence that you need to have a directors and officers insurance policy in place. So it's not typically, this is not really an issue, but more of a requirement because most early stage startups would not have had this insurance policy in place prior to an investor coming in. Moving to the next important point is with respect to lease. Now, in case you're working out of a leased premises, and if the lease deed is for a period which is more than 12 months, then it is required to be compulsorily registered and stamped in accordance with law. If you do not register such a lease deed, then irrespective of what you write as a term in your lease deed, it is deemed to be a month-to-month lease deed, which can be terminated within 15 days notice. So in case you do end up having a dispute with your landlord, and if you have more than 100 people sitting here, they can say that you need to vacate this premises within 15 days if such a deed is not registered, because technically they would be right under law. So do you have any which is more than 12 months that it is stamped and registered properly in accordance with law. The other issues that we typically see in lease agreements is that there are very, very stringent and very long lock-in periods. Now, in a very early stage startup, between Series A and Series B, they may expand a lot and they would need new office spaces. So do ensure that, while you're entering this contract, you look at the lock-in period and ensure it's not something arbitrary such as 3 years, because then in case you need to move to a bigger pace, you will have to break the lock-in period and pay a significant amount, typically the rent for the entire lock-in period. So do try and negotiate to have a much shorter lock-in period when you are an early stage startup taking up space. Do also ensure that your termination clauses, just like in the material contract section, are more considerate and not something like you need to give 6 months notice to your landlord before moving out. Have something which is more standard, such as a 2 months notice prior to moving out. And with some companies, when they begin in premises such as WeWork or Regus co-working spaces. There you will not have a lease agreement, so these issues will not crop up. But at any time that you do execute lease agreements, even as you grow, do ensure that you have the document properly vetted to ensure that all these loopholes are not present in your lease deed. The final thing that I would like to talk about is with respect to business-specific registration. While it would not be possible for us to cover all the various business-specific registrations in this CE, let me just take two simple ones which we do come across. In case you are importing or exporting any services or any goods, then you would need your registration under the importer-exporter code, and you would need to have that code in place. In case you are in, for instance, food retailing and you sell some food products online, then you need your FSSAI license under the FSSAI Act. This can be a state or a central license. So do ensure that, if you are supplying to various states some food items, that you have a particular license for all those states and not just the state in which you are based. So depending on whichever sector you're in, whether you're in tech or medtech, fintech, do ensure that your business specific law carefully looked at, because sometimes they require registration, and if you don't have that in place, it can pose to be an issue before the investor comes in. Back to you, Harshita.
Thank you, Anusha. Thank you for throwing light quickly on the D&O insurance policy, which again becomes a very big issue for the investors. The lease deeds, which are an important a component in terms of determining whether you can rightfully occupy the premises you are occupying or not. In terms of so when we're talking about the various laws which you need to comply with, another big and important law that you generally need to comply with, especially when you are having foreign investors coming on board, is the Foreign Exchange Regulation Act. While you're early stage and you may not have, you're still scouting for new investments, this section may not be really applicable to you. But in case you have any one round of investment which has come in through foreign funds or foreign individuals, you will need to carefully examine whether you've complied with the Foreign Exchange Management Act in terms of your, in terms of upkeeping, those areas. Aishwarya, if you could throw some light on whether the business of the company, allows for foreign investment, and how do you determine that, and how do you generally, align yourself to be on the safe side of the law in terms of foreign exchange control regulations?
Sure. Thank you, Harshita. So, so as Harshita mentioned, not India is a country which does not allow full capital account convertibility as yet. And there are some sectors where foreign investment is not permitted at all. And there are some sectors where it is permitted only up to a certain limit, or there are some sectors where it is permitted, fully, but with certain conditions. And in sectors where it is not permitted, foreign investment is not permitted or permitted up to a certain limit, to go above that certain limit, you will need to take government approval. So before getting ready to receive any foreign investment, a company must check if it is in a sector in which foreign investment is permitted and up to what extent is it permitted. And by receiving this foreign investment, up to how much is it, how much is its shareholding being increased by the foreign investment. So, and if you don't, you will be in violation of the foreign exchange laws in India, which is right now covered under the non-debt rules, and also the foreign direct investment policy, which will give you the various sectors and also how much is the foreign investment that is permitted. Then there are also pricing guidelines for investing into India, and also for the transfer of shares between a resident and a non-resident of shares of an Indian company. It is also important that you have a valuation report as on the date of the investment or transfer, at least a few days or months before the date of investment or transfer of these shares. So once a company has received investment and allotted shares to a non-resident, it must report it to the RBI, to the Reserve Bank of India, through its bank, through its authorized dealer bank. The RBI or the bank will verify whether the investment made was in compliance with the conditions for foreign investment and issue a registration number. So we see that most companies, miss seeking this registration number from the RBI or its authorized dealer bank. Sometimes you'll need to follow up with the authorized dealer bank to ensure that you get this registration number. Why is it important to get this registration number? Is because unless you have this registration number, any future share transfers by the investor holding these shares becomes slightly challenging, because especially future share transfers to a resident investor, if the investor, assuming that the investor is non-resident, will become slightly challenging and may not even be possible if this registration number is not available. So it's important that companies make sure that they get this registration number from the RBI and follow up. Over to you, Harshita. I think we're running out of time.
Thank you, Aishwarya. I think we've just bought some more time in from our tech team, so maybe we'll have another 5 minutes. Considering the paucity of time, we've also tried to answer as many questions as we can on the chat, on the Q&A window itself. So I think that is one place that we've helped. Just to end the session on a note, and we'll take up a few questions after that. So what does all this exercise of due diligence or conducting a due diligence by the investor, where does this culminate? And what is the conclusion to it? So 4 possible scenarios that we have seen, in terms of what happens once a due diligence is conducted. The first one obviously is that the investor tries to resolve as many issues as it can, through the help of the lawyers and advisors by your side. And once it is, and if it is not resolvable to that extent, it depends on how sticky those positions are and how grave those non-compliances are. If they are grave and non-rectifiable, we have seen situations when the investors have backed out from the investment deal. However, that's becoming slightly rare these days, because we're seeing that promoters are becoming cognizant to the legal compliances, and they are taking time out to ensure that the compliances and the house is generally in order. So it just doesn't really become a deal breaker to that extent. However, it's not something which hasn't happened, and so you should be very careful in when you're conducting a diligence, and as Anusha and Aishwarya have been mentioning throughout the session, not only when an investor picks it up, but ensure that once your company is up and running and you've incorporated, your compliances and your documents are in order from day one. So that when an investor comes in, you minimize the gap between the term sheet signing and the funds coming in. And you do not delay the process because a diligence is being conducted and there are issues coming out, and popping out from a diligence process. So to that extent, it may not turn out to be a deal breaker. The second, situation can be, bucketed in terms of your documentation. So when an investor sees issues, it can either club it as a condition precedent, which means that those issues need to be resolved prior to the funds coming in. Though those definitive documents in terms of shareholders and share subscription agreement can be signed, the investors may not put in their monies until those issues are rectified. They may put in a timeline to say 30 days, 60 days, or a 90-day timeline to finish those. But let me tell you, all the investors are, they generally look for the minimum timeline when it comes to rectification of those issues. So the team will be on fire in terms of pushing those issues to completion. So typically a 30 to 60-day window is something which is generally acceptable to the investors. If conditions precedent, if the action seems that it will take a little longer and the monies can be put in and there's a less risk involved in terms of pushing it to a condition subsequent, there are cases where the investors have agreed to push those items or rectification items to condition subsequent, which means that they are time bound. They do cast an obligation on the promoter and the company to complete it in a time bound manner immediately after the closing. Again, not more than a 30-day or a 45-day timeline is typically given for completing those exercises. And then there are consequences which are also pinned in the documents. So please do bear in mind that just because monies have flowed in from the investor and it's become a condition subsequent, that means you can take it easy. The answer is no, because there are penalties pinned into the document, which means that if the promoter or the company has failed to meet their obligations in terms of condition subsequent or otherwise, then the consequences shall follow. So ensure that if even if the investor has agreed for a CS, which is a condition subsequent, you will have to complete it in that, in the manner which has been agreed in the document. The third consequence that we've seen in terms of due diligence findings and how the investors react to it, they also place a specific indemnity, as they call. So while there is a general indemnity obligation cast upon the promoter and the company, in terms of anything that goes wrong with the document or any non-compliances, the investors shall have a right to seek an indemnity claim against the promoter. In case there is specific issues which are identified out of the diligence, which the investors are not comfortable with at all, and placing them into the CP or the CS bucket, they may ask the promoters to give a specific indemnity for that. They may, specific indemnity obligations can be uncapped as well. So you'll have to be very careful when you are agreeing to specific indemnity items there. So the shorter the bucket, or I would say if the bucket is nil in terms of specific indemnity, the better it is for the promoter. And the fourth is the disclosure letter, which is prepared by the promoters and submitted to the investors. So in terms of every non-compliance, while diligence is conducted and the investor is aware of what is wrong with the company and what are the issues emanating out of them, the investors will not. The diligence can never be a qualifier to your disclosures which have to be made in the document. So you have to accurately and completely disclose everything that is wrong with the company in your disclosure letter, which can be a cumbersome exercise if you have a lot of issues, popping up here and there in every section. So which is why, again, I go back to the same term that we've been using through the session. The key and the focus should be on compliance. While business and running the business is your priority, please ensure and ensure that your team also at all levels is compliant with what the law is expecting you to do. Because running a business in isolation with the legal compliances or the financial compliances may pose a big hassle to you. So that is about it for today's session, and we'll get back to you in terms of what is the topic for the next Thursday session. Meanwhile, we'll just quickly spend 5 minutes and see if there are any questions which remain unanswered, and we'll answer them. Anusha and Aishwarya, if you want to take up any question in the meanwhile, you can pick that up and answer it. So I'll pick up some 1 or 2 questions, which is a question saying, is there any online support available for documentation? So we're not sure if there's an online support which is available, and whether it's for documentation, it's a cookie cutter solution where you can just download a format or a document online and just roll it out to customers, suppliers, employees, etc. Because every contract has to be nuanced. Every contract has to be very specifically tailored to the circumstances of your case, whether it is an employee, whether it is a consultant, or it's a supplier or a customer. So you have to carefully look at and including your lease deeds. So do not pick up a template and use it as is in your businesses, because tomorrow you may have to modify it or can the document and create a new document, because if it doesn't satisfy the requirements of the investor. So I suggest, instead of picking templates online, you should create or curate your own templates basis your the requirements of the business that you're looking at. I think there's another question which says, can I attach the DD report to the disclosure letter? The answer is no, because the DD report is a privy document. It is rolled out by the investor's lawyers or the investor's advisors to the investor. It's a confidential report which is submitted to the investor. It is generally not rolled out to you guys as promoters or the companies. So while you may know the broad issues, because the investor is going to work with you or the advisors are going to work with you in solving those issues, you may not have the right to see the document in most cases. And additionally, the disclosure letter has to be drafted very carefully in terms of every section of the rep picked up and disclosed against. So you cannot disclose the entire diligence report against reps and warranties. That's just not acceptable and not the market to do it.
I think there is one question on digital signatures. So in case of agreements that are signed online across countries, so typically we see that we other than digital signatures, we sometimes also sign the agreement and send scans, and then we collate the originals. The other thing that even a digital signature certificate or a DocuSign is something that is accepted under the Information Technology Act. So these may also be documents or agreements may also be signed electronically in that way.
Okay, picking on another question, if the offer letter has the terms like in an employment agreement, will it be considered similar to an employment agreement? So employment documentation can be in various forms, and you can choose depending on how it suits your purpose. It can either be an offer letter, which is a short form offer letter where you're just confirming the appointment of the employee, followed by a detailed employment agreement which contains all the key clauses like IP protection, confidentiality, non-disclosure, non-compete, non-solicit, etc. Or you can alternatively have just one document, which is an offer letter, which contains these key terms. So the answer to your question is yes, you can have an offer letter, a detailed offer letter as we call it, which can contain these terms and conditions. But ensure that if you are looking to make the document enforceable, you should go ahead and stamp the document for better enforceability in your favor tomorrow. Anusha, is there anything else that you want to pick up? Otherwise, I think we're largely done with the Q&As. And we're
one question on litigation. I think someone has asked, how is litigation treated in LTD? Typically, in early stage startups, we do not see many litigations. However, if we see any litigation such as an accusation of fraud or breach of trust or misrepresentation on the founders, then that is taken very seriously and flagged off to the investors. But for other minor litigations, such as any takedown notice for which you have responded and removed any infringing content, most investors are okay with living with such non-compliance, as long as there's no further non-compliance going forward and a rep is taken to that effect. As the company grows, it is invariable, and if you're successful, you're 100%, you'll have many litigations that come in the form of tax or in the form of civil, when someone accuses you of selling a product which that is not in front of the consumer forum. So that, again, we look at it from a case-to-case basis, and depending on the facts of each case, determine whether it is so crucial that the investor's investment may be hampered, or it's something that we treat of every doing business and just flag off to the investor as FYI, these are all the litigations in the company. But if there's any IP infringement litigation where they're accusing you of the main IP on which your startup is based, then that again would be flagged off as a red flag issue to the investors to take it up on a principal to principal level. And also from a legal perspective, we would analyze as to what is the actual risk on it.
Thank you. I think with this note, we'll probably end this session and look forward to meeting, e-meeting all of you next Thursday with another interesting topic in continuation of the Founders 101 series. Thank you, all of you.